Constitution established Law Day as a day of national dedication and fresh renewal of commitment to the rule of law and to upholding the fundamental principles of governance enshrined in the Constitution of that great democracy. That memorable day was the 3rd of February 1958, but the celebration of the day was fixed as the 1st of May every year. Since then, we have been taking great liberties with the dates. But I must say that the practice of celebrating the Law Day has spread to all countries of the world, at least the democratic countries of the world, and it has certainly spread to our universities and campuses and law schools, and I am very happy that it is having some effect on the moral character of the young. The tradition that Eisenhower was talking about was one of adherence to the rule of law as the only safe and stable foundation for a free and just society. He was rightly proud of the memory and vigilance of the American people, that they had preserved their most precious heritage. Two important features of the proclamation that was issued on that day are worth noting. One was the international aspect of that document. Other was the domestic aspect, which was meant more for the citizens of the United States than the citizens of the world. In its international aspect, he pleaded for universal application of the principles of rule of law in the settlement of international disputes, which would greatly enhance the cause of just and enduring peace. And ladies and gentlemen, I must say that though this was a great thought which he incorporated in that document, the Indian Constitution and our makers of that great document had perhaps excelled him and preceded him in their wisdom by at least 18 years. The unique Indian Constitution has a feature which nobody of course cares to read, which is so unique that it is not found in the Constitution of any other country. That is the 51st article of our Constitution. It says that the state shall endeavor to first promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations in the dealings of organized peoples with one another. This article with these 3 clauses became a part of the draft constitution. But when the matter came to be debated in the Constituent Assembly, there were 2 old Gandhians who were still alive and had not forgotten Gandhiji. They got up and said, that is all right, you talk of these principles, but disputes are bound to arise. How do you propose to settle them? And that is how the 4th subclause was added to Article 51, and it is the reflection of Gandhi's aim that after India becomes independent, it shall become the conscience of the world. The 4th clause was to promote the settlement of all international disputes by arbitration. Ladies and gentlemen, I have a suspicion that no leader and no foreign minister of this country ever read this article. We never offered it to Pakistan, never offered it to China. We would have avoided disastrous wars that have taken place, the loss of money and the loss of life, and a humiliating defeat at that. However, that's a matter more for the cognizance of my friend, the law minister. Sir, on the internal content of this document, the bar should be proud that President Eisenhower pleaded for universal application of the principles of the rule of law, and called and summoned, especially urged the legal profession, along with press, radio, television and motion picture industries, to promote and participate in the observance of the Law Day. So, ladies and gentlemen, I think that lawyers have a great responsibility in enforcing this charter or the proclamation of the Law Day. Ladies and gentlemen, I don't have much time to go into it, nor have I any inclination to talk politics, but it is best to say that the rule of law is wholly repugnant to the rule of scams. 37% of India's population, contrary to the official figures, are living below the poverty line, and 2.5 million children every night go to bed without a morsel of food in their stomachs. Everybody has seriously to concern himself or herself with this state of affairs. Ladies and gentlemen, let me share a happy thought with you. We are not a poor country, and all lawyers and the entire family of lawyers, which includes all our judges, must combine to recover the enormous wealth that has been stolen by corrupt dacoits. The enormous amount that has been stolen is estimated at $1,500 billion, an amount which, if distributed in this country, will give 2.5 lakhs to every Indian family, will wipe out our national debt overnight. And ladies and gentlemen, for 30 years you will have a tax-free budget. I regret to say that neither the entire bar, with distinguished exceptions, nor even the Supreme Court, to whose attention this great dacoity has been brought to its notice, I don't think that there has been that kind of an anxiety to recover back this amount and to send these dacoits to the place where they rightly belong. I will say no more, but ladies and gentlemen, I am reminded that when Charles I was ordered to be executed for fighting a war against the Parliament and the people of England, and his head was about a minute or two before it was to be severed, he said that I am getting out of an corruptible crown and I am going now to get into an incorruptible crown. I don't know whether he got it, but ladies and gentlemen, at least ensure that all our corrupt people do get into that incorruptible region. How they will contend with God, I don't know. Do at least send them to a more powerful and potent Supreme Court of Providence. The celebration of Law Day, ladies and gentlemen, has been adopted in most countries, and I am glad by the Supreme Court, where I have the honor of being President of the Bar, and the Symbiosis College, where I teach. In that college, we administer to the faculty and students an oath of this kind every year. I hope you will have approved of it today, and we will take it every law day in future. But ladies and gentlemen, the oath is a serious oath. After all, judges don't dispense judges and record evidence without giving the oath to people. Now I have given an oath to all of you. Thank you.
Thank you, Mr. Jethmalani, for such an illuminating and hard-hitting speech. Now, may I call upon the Attorney General, Mr. Gulam Vahanvati, to deliver his speech.
My Lord, the Chief Justice of India, Justice Kapadia, the Honorable Union Minister of Law and Justice, Dr. Veerappa Moily, the Honorable Judges of the Supreme Court, Chief Justice of the Delhi High Court, Judges of the Delhi High Court, Mr. Jethmalani, President of the Supreme Court Bar Association, and a father figure for me, the learned Solicitor General, law officers, office bearers of the Supreme Court Bar Association, and friends. Ironically, the topic on which I chose to speak today was the rule of law. These are troubled times and the rule of law is under strain. And on my own, without knowing the new pledge we were going to take about the rule of law, I thought I could share some important thoughts with you. The rule of law as a concept has a great historical lineage. It is traced to ancient Greece, to that great philosopher Aristotle. And ironically, it was the progressive Greek civilization which gave rise to the Western concept of democracy, and the undemocratic Roman Empire which gave birth to the Western tradition of a well-codified body of law. And then many years later, in the 13th century, came the Magna Carta, under which the King of England pledged that no man in his kingdom would be seized or imprisoned except with the lawful authority of the law of the land. The rule of law is a kaleidoscope which can be looked at from many angles. In 1953, the Supreme Court said that the rule of law eschews legislation which singles out a particular individual and imposes a disability on him which is not visited on others. The next year, the Supreme Court said that the rule of law means that the state cannot interfere with the rights of persons unless there is a specific law authorizing their acts. In 1961, this court said that the rule of law meant that the government cannot take law into its own hands, nor can it dispossess people without the authority of law. And 20 years ago, in 1990, the Supreme Court said that the basic postulate of the rule of law is the absence of unguided discretion, so that discretion must be conferred within clearly defined limits. So there you have 4 different key cases with 4 different aspects of the rule of law. And if you look at it from this point of view, it ceases to be an esoteric concept but becomes live and vibrant. What then are the various aspects of the rule of law? Firstly, it is based on the recognition of essential human rights. It is concerned with the liberty of the individual, government, and equally important, respect for a lawful government by citizens. A government of laws is organized under a basic organic law, the Constitution, and the making, enforcement, and interpretation of laws is entrusted to institutions set up under the Constitution. The legislature makes the law, the executive enforces the law, and the judiciary interprets the law. Montesquieu wrote as far back as in 1748 in L'Esprit des Lois that the most important aspect of the organization of the state was the separation of powers. Because if the executive power and the judicial powers combine in the same person, then this becomes oppressive. Of late, the rule of law is under strain. And one of the causes for the strain in the rule of law is how the institutions under the constitutions are themselves contributing to the strain to the rule of law. I call these inner conflicts, unease within the institutions themselves. It is disconcerting to observe that there is widespread popular disillusionment, and this to a large extent comes from intra-institutional pressures. Ideally, the legislatures were meant to be composed of mature elected representatives of the people who contested elections on issues, sought political power to implement these issues for the betterment of society. Traditionally, before passing laws, legislators discussed, analyzed, and debated on proposed legislation. Authors have criticized that legislative assemblies have become mere rubber stamps and legislation is rushed through in between disruptions and turmoil. We cannot say that this criticism is unfounded. As far as the executive is concerned, the politically elected people head the Council of Ministers, but the bureaucracy is also the fulcrum of the executive. Here also there is a strain. When I took over as the Advocate General of Maharashtra in 1999, my predecessor told me that he had sat on a file for an opinion for a long time. And that was whether a bureaucrat can refuse to implement an order passed by a minister. I took the view that he has no choice but to implement it. But he must then write on the file the reasons why, according to him, the order of the minister was not illegal. If he brings it to the attention of the minister and says that this is why I think your order should not be implemented, and the minister insists on it, then he has no choice but to implement it. Because ultimately the ministers are responsible to the legislatures and they are responsible to the people. This really doesn't happen, and every change of government sees changes in bureaucrats, and the reason for this is not far to seek. Our police force has also been grossly underprepared, and the Mumbai attacks of 26/11 showed the cracks in our system. Fortunately, there is now a serious effort to improve the preparedness of the people and paramilitary forces, but a lot more remains to be done. Ultimately, society revolves around what Robert McIver called the myth of authority. The myth of authority is the myth that people believe that the police can control law and order at all times. But in fact, the police can control only 3% of the lawbreakers in the entire population. And if it goes to 7%, then law and order breaks down. But there must be belief in the system that the police will be able to control a situation. And if this doesn't happen, then the system gets under strain. The judiciary remains a highly respected institution. People have still faith in the judiciary, and the faith is not misplaced. But of late, the judiciary is also coming under increasing public glare and criticism. Some events, like for instance, the impeachment of a particular judge which is pending in Parliament, prosecutions which have been launched in respect of the cash at door, which was sought to be launched in respect of the cash at the door incident in Punjab, the Ghaziabad Provident Fund scam, have tarnished the image of the judiciary. Another important aspect where I believe it's time for us to introspect is whether judicial discipline is fast disappearing. Precedents are the lifeblood of the legal system. Stare decisis is the basis on which we work. In fact, in 1865, the system of printing official law reports came under the control of the Incorporated Council of Law Reporting. But now, frequently, judges are differing from earlier decisions and referring matters to larger benches, where the principle earlier that judgments are binding and can be disagreed with only for very valid cause no longer seems to be applicable. I am conscious that PILs have come to stay, and we must accept it as an important aspect of our system. The law minister at a recent seminar on PILs said that the executive itself is to blame for the increase in PILs because it is not doing its job, but it's leaving it to the judiciary to sort out various vexed issues. But the question is this being misused? And are PILs being used to bring shady questions before the court? That's a question we all have to answer very seriously. Ladies and gentlemen, I flag these issues with every degree of responsibility and with the greatest caution which was available to me. But I do believe we must recognize that the situation is grim. We must pause and take a hard look at the system. After all, the rule of law must be preserved at all costs. Thank you.
Thank you, sir. Now, may I call upon Honorable Union Law Minister, Mr. M. Veerappa Moily, to give his address. Honorable Law Minister.
Honorable Mr. Justice S. Kapadia, our Bhishmacharya of the family of legal fraternity, Mr. Jethmalani, Mr. G. Vahanvati, Attorney General of India, Mr. Gopal Subramanium, the Solicitor General of India, Mr. P.K. Jain, Vice President, Honorable Judges of the Supreme Court, Honorable Judges of the High Court, Honorable Justice Deepak Mishra, Chief Justice of Delhi High Court, senior advocates, my brother advocates, friends. I am today participating as a lawyer, having taken the Law Day oath on the Charter, and of course, Mr. Jethmalani has invited me as a law minister. It's a great day for all of us. In fact, I had the occasion to participate last year also. In the indomitable style, as it were, Mr. Jethmalani has set out the charter for all of us. I accept that. More than 6 decades ago, a body with a unique mandate to deliver to a nation newly born a roadmap of the life and light came to a close, and this enlightened assembly returned its work in the form of a unique document. The unique document, christened as the Indian Constitution, sprang to life, albeit limitedly, underlying the will of this nation, that it shall not be governed by whims and fancies, not by dogma, but determination, but most importantly, that India has chosen a new master, that we the people of sovereign democratic of India have submitted ourselves to the rule of law. Edmund Burke used to say that the study of law renders men acute, and they are able to augur misgovernment at a distance and snipe the approach of tyranny in every tainted breeze. That's our strength. That's why we are able to we are also feared, particularly by those in power and authority. The Prime Minister, Dr. Manmohan Singh, in his inaugural address at Indira Gandhi Conference on 19/11/2010 said that our national movement began as a struggle for freedom, but became a mighty fight for democracy. Swaraj is my birthright, said Lokmanya Tilak, and so this idea of nationhood within diverse people. But we did not seek freedom for freedom's sake. We sought freedom to liberate ourselves from centuries of misrule, from scourge of poverty, ignorance and disease, from tyranny and bigotry, from caste prejudices and communal divisions. Thus, the Constitution of India was a unique social charter, the oldest statement ever of social democracy. Lord Atkin once said that an impartial administration of the law is like oxygen in the air. People know and care little about it till it is withdrawn. Unquote. Law has several aims. They are all concerned with making society more stable and enabling people to flourish. One way of doing this is to set up an official framework of compulsion. If people disobey the rules, the law threatens them with something unpleasant, like being punished or having to pay compensation. If they are more secure, they will treat one another better. A second aim is to provide facilities for people to make their own arrangements. Law guarantees to people who buy and sell goods, make wills, take employment, form companies, and so on, that the state will, if necessary, enforce this arrangement. Third aim is to settle disputes about what the law is and whether it has been broken. Taking these three aims together, we see that law not only threatens those who do what it forbids, but promises to protect people's interests. Lastly, a very important aim of law is to settle what the system of government is to be. Though the threat of punishment and other sanctions are often effective in the short run, In the long run, law has to build on a basis of morality and self-interest. In this way, law and moral opinion support one another. Morality is incomplete without law, and the law can only be enforced when it is backed by morality and self-interest. To find the right or best solution to an unsolved problem calls for learning, wisdom, and restraint. Learning, the decision must be consistent with the history and traditions of a society and its laws. When I specifically greet this audience today, I begin by giving you the congratulations of a grateful nation who have kept alive the tradition and memory of the day when we took this short but determined step towards the Constitution. I salute the judiciary for keeping the nation above every interest. I ask, however, today is that it is this festival of lawyers alone, a theme which I have chosen to address this lecture. The phrase largely popularized by Dicey's assessment of the English administrative relationship was an argument as to how the English system was better than its continental cousin. He argued that the idea of rule of law is a mark of a society which has come to a full circle, as is subject to government of order and reason, but order and reason nevertheless. I have not got a brief from Ram Jethmalani. It is my own brief. Because he started with the rule of law. I think I am, and Vahanvati continued it. I think I am taking to a logical conclusion. Today, India not only has a constitution which has grown organically over the last 6 decades, but has withstood dark hours, pregnant silences, and a changing fabric, but one which has had the system execute and administer it. The problem arises is when we introspect to see whether the practices has been loyal to its theory. Though it would be unfair to say that we have failed, it would also be fair to say that large gaps are still present. In the last 2 decades of the 20th century, and from the beginning of this century, first the courts, much more. The most important among them is a pronounced awareness among the common people about their rights and its consequential assertion in courts. The second being the spate of legislation, both by parliament and state legislatures, in order to balance the conflicting rights in a growing complex social situation. The third factor, which is linked with the other two, is the affirmative role of the courts in upholding the rights of the common man by opening new areas in our jurisprudence. Of late, there has been a good amount of talk on accountability. When seen in the context of rule of law, it addresses the core belief that systems are superior to people, and that where there are serious concerns, it is enough to put systems above people, change people in the system. In our idealistic overtones, we often go too far from the ambit of practicality when we speak of ideality. One is not saying that it's not an ideal worth inspiring, but then as human beings are imperfect, the blemishes do come into the system. A rule of law system can never ensure, and neither can any system that become perfect. But what a rule of law does is to ensure that when rules are broken, the law will hold you accountable. By a rule of law regime, system holding persons accountable in power, we do not mean that it is the courts which will call the government to power. We mean it is a system which is self-accountable. Rule of law means the right combination of statesmanship, political magnanimity, flexible but definite legislative address, separation of power, checks and balances, administrative efficiency, and a strong and independent judiciary. Together, these account for speaking responsibility to power, and if you look at the days before us, you will see that where each of these elements have come in, the rule of law has spoken and accountability has been accounted for, and where any one of these has been missing or where we are continuing in denial of the rule of law shall not prevail. Rule of law can never come for a quarter. It comes from each of the quarters. which collectively constitute a system. And only then we can achieve order and accountability in the end. Friends, members of the bar, please remember that this is that it is you who have most access to each of these quarters. And these calls for accountability shall have to come from you, for you have given us actors in all the three wings of the state. Today, when the system, rather than the people who constitute our question, it becomes a problem of immediate address, and therefore step in and step to redress this concern as you have done in the past. A lawyer is concerned then to find the best solution to a conflict that is consistent with the authority of the Constitution. The just decision is often, I believe, the decision that an impartial and well-informed person will arrive at after carefully considering the facts and the arguments on both sides. Not all judges and lawyers have these qualities, but if they do, the society they serve comes as close to justice as it is possible to get. This is what the theme of the charter today, and I must say again that brain is a computer and the consciousness is like computer program. This is where we are. I congratulate Mr. Ram Jethmalani for the revised chapter which has been provided to us, and we owe a great deal to him, and I congratulate the Bar Association for setting up this function and inviting me. Thank you very much. Jai Hind.
Thank you, Honorable Law Minister. May I now request Honorable Chief Justice of India, Justice S.H.
Of the
Kapadia.
Supreme Court, Shri Veerappa Moily, the Union Law Minister, Shri Deepak Mishra, the learned Chief Justice of the Delhi High Court, other judges of the Delhi High Court, senior advocates of the Supreme Court, Attorney General of India, Shri Gulam Vahanvati, Shri Gopal Subramanium, Solicitor General of India, and above all, my friend Mr. Ram Jethmalani, who is the President, and other members of the Bar Association. As far as Mr. Ram Jethmalani is concerned, I can say one thing, that I have seen the only person for last 30 years who I can call as out-of-box thinker. I remember I always recognized him as a criminal lawyer, but once in Bombay when he argued a Negotiable Instruments Act, I was thrilled the new concepts which he brought in, and it was so enthralling that I sat in that court, I distinctly remember, for almost 20 days making my notes. I was not in the matter. But this is the credibility of Shri Ram Jethmalani which I wanted to highlight today in this function, particularly when he gave this oath. See the out-of-box thinking which comes there. With these words, friends, let me say that today is a solemn day. I would like to say that when the constitution makers framed the constitution, they were certainly impressed and inspired by Universal Declaration of Human Rights. But the most important thing as I see it is that they were inspired by the title deeds to the Constitution, which title deeds were written in the blood and the sacrifice of the freedom fighters. Our Constitution framers drew inspiration from those sacrifices, and it is that is why the reason they incorporated the Fundamental Rights chapter, and they elevated the human individual dignity to the human rights jurisprudence, not only in the fundamental rights chapter, but also in what we call as the preamble to the Constitution. The Constitution framers were concerned with conversion of dominion into republic. They also sought to achieve inclusive society, which is very important today. When 300 million people today are referring to the economic growth, 700 million people are facing acute difficult problems, particularly on account of price inflation. It is on this day, therefore, let us take annual stock of the steps which we have taken in the past and of the future challenges that which we have to meet in near future. One of the reasons for docket explosion is due to the growing modern society. In today's economic resurgence, competition is bound to be there. It is a good thing. But along with that, greed comes in. And with greed, you have corruption, and which leads to problems, and including docket explosion. You have frivolous litigation, which blocks out the good causes in the process, and therefore the courts have to be very strict with regard to PILs which are having frivolous litigations. I would request the lawyers to be circumspect when taking up such causes. To give an example, today we had a PIL which we dismissed, and therefore I am referring to it. A writ petition is filed, please declare the Allahabad judgment as null and void. Is it not a frivolous litigation? Now if these type of petitions are filed, certainly the good causes would suffer. The judges have to devote hours reading the files, and this is what the courts should be very careful about. As far as the role of the judges are concerned, particularly in the High Court and in the Supreme Court, my advice to them is judicial review is a toolbox. Please open it only in genuine cases. Please do not open that box in every matter. And that is why I again say that the cause which we judges have to serve is the correct and coherent interpretation of the Constitution. In every matter, we must know the width of our powers. We must also know the contours of the rights and accordingly decide the matter, give justice in accordance with law. We cannot interfere in every issue of policy. We cannot interfere in the governance of the country, and otherwise we will be like a bull in the china shop. These are the advice as far as my brother judges are concerned. Now coming to the areas is concerned, areas in the court. For last couple of years, we are told that the judge population ratio is only 12 to 13 per million. It is a fact. But friends, this population, judge population ratio is the function of the growth in the population. And in India, we are growing at the rate of 43,000 per day. If this is the rate at which our population is growing, the judge population ratio cannot sustain. It has to increase, no doubt. But is it increasing in tandem with the population growth? Answer is no. What is the consequence? The consequence is that 14,000 judicial officers are expected to dispose of 2.79 crore cases, and in the High Court, 610 High Court judges are expected to dispose of 40 lakh cases, 42 lakh cases. Here also, my statistics indicate a very interesting feature. Allahabad has 9.62 lakh cases in arrears, whereas Gujarat has got only 95,000 cases, Delhi has got only 62,000 cases. So please, we have to now analyze and we have to prepare a statistical data to indicate whereby we can lay down certain norms by which certain cases can be given preference, so that at least in those high courts where the huge backlog is there, we can devise some method by which we get quick disposal of cases. Lastly, I want to tell the gathering today, unless we do something for the subordinate judiciary, we will not be able to progress as far as the challenges are concerned. I have been visiting each court, and I remember before I became the Chief Justice of India, it was Mr. Fali Nariman who advised me. He told me, sir, time has come, please visit the courts, you will get the first-hand information. And it is that advice which I have been following till today by visiting various states. Now see the problems which I would like to highlight, and then please keep these problems in mind and see the statistical disposal given by the subordinate judges, and I think we need to salute them for that. When I went to Maharashtra, for example, I had an interaction with the subordinate judges. There was one lady district judge. She came from an area which was having some problems, Naxal problems, etc. She told me in the conference that a magistrate, a lady magistrate, does not have a rest room in the courthouse, and in emergency she has to rush back to her residence because there is no rest house. Now why that restroom is not there for lady judges? Because the courthouse is there in a private accommodation and the landlord wants the premises back. So he does not provide for any infrastructure. In these conditions our judges are working. Judges are also part of we the people, which is there in the preamble of the Constitution. Further, magistrate courts are housed in certain states in cowsheds. They are housed under the staircases. They don't have proper chambers. Magistrates are living in the residential houses which are owned by litigants. How do you expect them to deliver justice, to have with all these problems? I can go on enumerating. There are no cupboards to keep even the valuables in the court. See the case of staff paucity. I will give you an example. When a court is set up, the government says, I will provide 2 clerks because the expectancy is that the judge will clear about 1,000 files. But even when the files go from 1,000 to 6,000, they will not increase the number of clerks. The result that it is impossible for the judge. In fact, in most cases, the judge has to write down his orders. There are no proper typewriters, forget the computers. Now with all these problems, kindly see the work done by the subordinate courts as far as the disposal is concerned. Firstly, the institution between 1st April 2010 to 30th June 2010 in the subordinate courts was 43,80,000, and they have given me a disposal of 40,12,535 even with these problems. In the High Court, the institution is 4.17 lakhs during the same period of April 2010 to June 2010, and the disposal is 3,50,000. In the Supreme Court, after I took over, Friends, the areas have come down within 3 months by 2,000 cases, number one. Number two, the areas in the Supreme Court, if you remove the 1-year criteria of pendency, is not 54,000, it is 35,292. And I must say that it is all due to the effort of my judges that even within 3 months, we have been able to bring down this case areas by at least 2,500 matters. Friends, when I went to subordinate courts, I was told by young, bright judicial officers, very bright, very good in computer, that sir, we don't have any updation as far as computers are concerned, but the main problem is there is no electricity. After I sat in the infrastructure bench, again I must acknowledge the services rendered by Mr. Nariman as amicus at the age of 80 plus. And because of that, please follow one thing. In Maharashtra, double feeder lines are provided to 10 districts and express feeder lines are given to 7 districts, and zero load shedding schemes are given to 27 court complexes. And today I have received a letter that we do not have electricity problems and laptops have started working. Now this is what we need to work on. Theory, speeches, etc., it's all right. Rhetoric will give me good entertainment, but I expect performance which has to lead to outcome. As far as the Supreme Court is concerned, friends, I have taken various steps to see that there is some space created, and in that direction I went into the basement and I found that the air conditioner ducts are on the ground. So we have decided to lift it to the ceiling, and if that is done, I will get 10,000 square feet area where I can put at least 40 cupboards, and that would possibly release the pressure which is there on my officers. Some of my officers got TB because they have been working in the basement. We did not have a luggage lift to be carried from the basement to the first floor. So we have got the luggage lift installed. We are taking steps to lift the ducts which I told you. We are constructing PRO offices. We have also hired 2 rooms from the Delhi High Court, for which I am grateful to the Chief Justice of the Delhi High Court, where we can shift some old files. An important thing to be noted is that we have weeded out in the process 25,000 paper books and 55,000 kilograms of raddi, which was never touched by anyone. It was just lying in all these offices, and we had to clear it in order to create space. These are some of the steps which we have taken as far as the Supreme Court is concerned. Friends, when I saw the poverty which is there in some of my staff members, I have sanctioned compassionate appointments at least for 12 junior court attendants, which application was pending for last 3 years. I have given 1 advance increment to the canteen workers. I have given special incentive for hard posting, people who are working in the basement. So they will be getting an incentive of rupees 750 per month. I have also seen to it that a translation cell is set up in the Supreme Court. We have already in the process, it is in the final stage where we will get good translators for official translation. We have also recruited judicial officers on deputation so that they can do the work of clubbing. And we have taken steps to, because in most of the cases I find that service is taking considerable time, and therefore we must make use of the technology which we have. In conclusion, friends, I would like to say that I am thankful to the members of the Bar Association here not only for asking me to participate in this function, but I can dare say that this Bar Association headed by Mr. Ram Jethmalani and Mr. Bansal has really extended very good cooperation after I become the Chief Justice of India, for which I am deeply obliged, and I have to place this fact in public domain. Having said this, I must also thank my colleagues for the cooperation they have extended, both in the administration as well as on the judicial side, including the members of the collegium. Friends, my earnest ambition is that within the existing system, I shall prove within 2 years that we can have good judges and we will have good efficiency in the judicial system. With these words, friends, let us this year be dedicated to what I would call as an investment in the judiciary. The government has really given me financial support. They have definitely evolved a good vision statement. We are working on those lines. In the next year, I will give you the outcome of the steps we have taken in the E-Committee. And in the end, friends, I would like to thank the Law Minister and the government for releasing a sum of rupees 60 crores towards computerization between April 2010 to October 2010. And I must also give credit to the Law Ministry who took the initiative under a special drive in between January and October 2010, under which 2,48,153 under trials are released in the last 10 months. So I am closing my speech hopefully with the positive credit balance, and I hope that the credit balance will grow in future. Thank you.
I wish to thank personally Honorable Chief Justice of India for saying some encouraging words about the present Executive Committee. And I assure Honorable Chief Justice of India, as I have been telling in all the functions, that this Executive Committee would definitely and always cooperate with the Honorable Chief Justice of India in any manner whatsoever, if it is for the betterment of rule of law, for administration of justice, or for the welfare of the Bar Association. So I assure Honorable Chief Justice that he can count on this present Executive Committee. Now with this, I just want to add what Honorable Chief Justice has just said. There are few concerns of the Bar Association also, which I may take this opportunity to highlight, particularly in respect of appointment of judges in the High Court and designation of senior from the members of the Bar. I wish to take attention of the Honorable Chief Justice only for a minute, just to highlight the fact that the lawyers who are regularly practicing in Supreme Court, who are not practicing or appearing in other high courts, are not considered while appointment in the concerned High Court, because in Supreme Court we have lawyers from throughout the country, and normally the Collegium of the High Court would consider a person who is practicing in that particular High Court. So the lawyers who are regular practitioners of this Honorable Court, they are at disadvantage. So I would request Honorable Chief Justice of India as well as Honorable Law Minister to formulate some policy where the regular practitioners of the Supreme Court also may be considered for the appointment and elevation as the High Court Justice. Apart from that, there is another issue which has been brought to the notice of the Executive Committee, which I would like to highlight, is the designation as senior. Different High Courts have different set of norms for designation as seniors. As far as Supreme Court Bar Association is concerned, my humble request to the Honorable Chief Justice of India would be that the system of designation of the senior should be absolutely transparent, and some say of the Bar Association may be heard in the process. I don't say that it has to be binding, but definitely at some stage the Bar Association may be consulted. It would be highly appreciated and taken well by the Bar Association. Apart from that, the last issue is about the construction of more chambers for the lawyers, which is a long pending demand. Of course, the land has already been allotted for Appughar to the Supreme Court of India, and I hope that there will be some consideration, as the Honorable Chief Justice has given us the understanding that we are in the scheme of things. But I do hope that if not at this land, maybe some land adjoining this land may be allotted by the government for construction of more chambers for lawyers. So this is my another request to the dignitaries. So with this, honorable members, the tradition of honoring our senior members of the bar who have completed 50 years of practice in the court is an old tradition on this Law Day function. So for this, the executive committee has recommended few names. So I request Ms. Neena Gupta, member executive. Oh, I'm sorry. I request Shri Sandeep Singh, member executive, to come up on the stage and announce those names.
Honorary dignitaries on the dais, and my dear friends. Today, we are already know that we are assembled here to celebrate the Law Day. On this occasion, the Supreme Court, Bar Association and Executive Committee have decided to facilitate the members of the bar who have completed 50 years of practice in the Supreme Court Bar Association. I felicitate two names, Mr. Jagmohan Khanna and Mr. SCBA Sh, Senior Advocate. Before I facilitate, I give you some brief introduction regarding to Jagmohan Khanna. Jagmohan Khanna, a prominent lawyer of Supreme Court of India, who was born at Lahore on 25th February 1938. His father, Shri Ram Bahadur Tiratram, was an eminent lawyer and the president of District Bar Association Lahore for many years, and migrated to India in 1959. He enrolled with the Bar Council in the year 1962 and became AOR in 1968, and is practicing in Supreme Court of India since then. Now I call upon Mr. Jagmohan Sharma to come on the stage and to receive the memento. Now I request
Shri J.M. Khanna.
Now I request Mr. Chief Justice to give him a memento on this occasion.
Please come forward, sir. Please come forward. Yeah, please come. Just come here. Yeah, please, sir. Thank you, sir.
Before call upon Mr. SCBA Sh, Senior Advocate, I want to do a brief introduction. He was born in 1942 in the small district Muzaffarnagar, UP. He passed LLB from the Meerut College, Meerut, in the year 1960 and joined the Meerut Bar Association in 1961. He was appointed the Additional Advocate General UP in Allahabad High Court in the year 1982. Then he shifted to the Supreme Court of India, where he was designated as a Senior Advocate in the year 1985. He has completed 15 years of the professional career successfully right from the Municipal Court to the Supreme Court of India. Now requesting Mr. SCBA Sh to come on the stage.
Yeah, please, sir, this time.
And Shri SCBA Sh, Senior Advocates, and the Bar Association feels honored to felicitate both the members. Now, every year in AOR examination, the toppers are felicitated and medals are presented on behalf of the registry and on behalf of Mukesh Goswami Memorial Trust. So I request Ms. Neena Gupta, member executive, to come up on the stage and declare the names of the toppers of the AOR examination held in June 2009. Ms. Neena.
Honorable dignitaries on the dais and those present in the audience and my dear friends, I have the pleasure of announcing the names of the toppers of the year 2009 Advocate on Record Examination in the Supreme Court of India. Manish, can you please come here to help me? For the first position, there has been a tie between Ms. Suman Kukreti and Mr. Mukul Kumar. I request Ms. Kukreti and Mr. Mukul Kumar, advocates on record, to kindly come on the stage and receive gold medal, Chief Justice of India.
Please come forward, please, ma'am. Yeah, just wait. Yeah.
I now request the Honorable Law Minister to present Mukesh Goswami Memorial Fund Certificates of Distinction to these two toppers.
They have tied on one particular number, so that must be a lucky number. Check.
I request Mr. Jethmalani, President Supreme Court Bar Association, to present checks for rupees 501 each on behalf of the Supreme Court Bar Association and checks for rupees 2,501 each in the memory of late Shri Rangarajan T. Kumara Mangalam, sponsored by the family of late Kumara Mangalam. Congratulations. Advocate on record to come on the stage and receive his silver medal for securing second position in the Advocate on Record examination from the Honorable Chief Justice of India.
Because this is a burden, so it would be much better.
Your Lordship, please.
I request Honorable Law Minister to hand over Mukesh Goswami Memorial Fund Certificate of Distinction to Mr. Ankur Mikal. Mr. Jethmalani is requested to kindly hand over check of rupees 501 on behalf of Supreme Court Bar Association of India.
This is the tradition, sir. That's what
It's a tradition. It's a token. It's not a bribe. Thank you.
I congratulate all the three toppers. Now, may I call Mr. Anil Huda, Assistant Secretary, to declare the names of the persons who have given who have written law books during the last year and who are felicitated on every law day. So I request Mr. Anil Huda, Assistant Secretary, to declare the names and call upon the persons who have their honors. Thank you.
Honorable Chief Justice of India, Honorable Law Minister of India, Honorable Attorney General for India, our beloved President Mr. Jethmalani and other dignitaries on the dais, Honorable Judges of the Supreme Court of India, the Chief Justice of Delhi High Court and other judges of the Delhi High Court, and ladies and gentlemen. On the occasion of Law Day, we honor the members of the bar who publish books on different subjects relating to law. May I now invite Justice T.S. Doabia on the stage. He has written a book on environment and pollution laws in India, which is in 2 volumes. I request the Honorable Law Minister to give the certificate to Mr. Justice T.S. Doabia. Now, now I request Dr. Janak Raj J, who have written a book, two books on one on motor accident claims and other on bail law and procedures, to come on the stage. Okay, Mr. Dr. Janak Raj J. Mr. Lalit Bazin have written a book on media, Word the Law. he is out of station, that I have been informed. I request Ms. Neena Bhasin, wife of Mr. Lalit Bhasin, to take the certificate on his behalf. The Law Minister will give the certificate to the wife of Mr. Lalit Bhasin.
Ma'am, please this side, please.
May I call upon stage Mr. H.L. Kumar, who have written a long list of books. Some of them, the list is as follows. One is labor laws, labor problems and remedies, practical guide to employees' state insurance. Next one is Delhi's School Education Act and rules. Then leave, holidays and absenteeism in industries. Then labor laws, employees, public employees act rules and schemes, obligations of employers, compliances under labor laws. All the books have been written by him. We have been writing books so often on labor laws. Now I call upon stage Mr. Harbanslal Sari, who have written a book on petroleum laws. Mr. Sari is not here just now. If someone else is there from then Mr. Raj Panjwani, who have written a book on animal laws of India. He is here. I request the Law Minister of India, Mr. Panjwani.
Yes, sir.
Now I request Mr. Anirudh Vatva and Anirudh Krishnan, who are the co-authors, who have written a book on Law of Arbitration and Conciliation, which is 5th edition. Mr. Anirudh Krishnan is not here, he is in Oxford University, UK. I request Rahul Srivastava, CEO of LexisNexis, who have published the book, to take his certificate. Who will be receiving the certificate for Anirudh Krishnan. Now Mr. Kapil Wadhwa, who have written a book on trademarks and passing off, is here. I request the Honorable Law Minister to give a certificate. Yeah. Now, I request Mr. Ashwani Kumar Bansal and Deepak Jindal, who have written books on e-book for young advocate, things you must know in legal practice. I will request the, Mr. Gulam Vahanvati. Next, Mr. J.K. Mittal. Mr. J.K. Mittal have written a book on law, practice and procedure of service law, which is in 2 volumes, and also on law and case references. I think he is not here just now. Someone else on his behalf is coming, who will receive the certificate for him. I request the Attorney General for India to give certificate. Next in the list is Mr. Charan Lal Sahu, who have written about Presidents of America and India. I request Mr. Charan Lal Sahu.
एक ही पे चलेगा कितने पे चलेगा 2 पे चलेगा
I request Mr. Surinder Pal Singh and Mr. Rajendra Pal Singh, who have co-authored this book, Petitions for Under Trials and Prisoners.
Thank you, sir.
Mr. Rajendra Pal Singh is not here. Mr. Surinder Pal Singh will be receiving the certificate on his behalf also. Someone says, so as to save time.
Yep.
Mr. Kantwani has written a book on the Digest of Arbitration Conciliation Act 1926 and Law of Easement and Licenses. I request to give the certificate. Ms. Jyotika Kalra have written a book on recovery through complaints. Ms. Jyotika Kalra. Mr. Rajkumar Gupta, who have written a book on Babu Rish Bajji, great freedom fighter. I tell you, Babu Brishbanj's father of the Supreme Court judge who retired, Mr. Ashok Bhan, he was also as Chief Minister of Petsu, Joint Punjab. I request Dr. Ashok Dhamija, who have written a book on various topics on Prevention of Corruption Act, Law of Bail, Arrest and Custody, the need to amend the Constitution and Doctrine of Basic Features. I request the Attorney General to give certificate to him. Now, last I call upon Ms. Bhavna Thapuri, who have written a book on frequency. Ms. Bhavna Thakur is a budding lawyer practicing Supreme Court only.
Yeah, ma'am, this side.
I thank the Honorable Law Minister for India and the Attorney General for giving away the certificates. Thank you very much.
Now we approach the end of the function, and I take upon myself the onerous duty of paying a vote of thanks. First of all, I would thank Honorable Chief Justice of India for being a chief guest on this occasion, and along with that I thank all the honorable judges of the Supreme Court and High Court who have taken out time to be present on this occasion. I sincerely thank Honorable Law Minister, the Honorable Attorney General for India, Honorable Solicitor General of India, Honorable Judges of the High Court, and Honorable Members of the Bar who are sitting here till this hour and who have made this function a success. I wish to thank Mr. Jethmalani, President, under whose able guidance and leadership this Executive Committee is working, and I hope it will make a difference this year. I sincerely thank the Executive Committee of the Supreme Court Bar Association, with whose support and active guidance this function has been made possible. Further to this, I also wish to make a sincere thanks to the Registry of the Supreme Court as well as the security, who have spent lot of time helping us to organize this function. Along with this, I request all of you to join us for tea, and lastly, the staff of the Supreme Court Bar Association has been working day and night to make this function a success. So I personally thank the staff of the Supreme Court Bar Association who have made this function a success. Thank you very much. I invite all of you for a cup of tea. Thank you.
ये सही कह रहा हूँ जी, वहाँ पे पीछे फाड़ दिया, वहाँ पे खाई थी, वहाँ से बनता उन्होंने अपनी सीट पर ही रख रखी है। क्या कहते भैया,